Welcome to News Hour by DLC, your one stop destination for the latest and most impactful updates from the legal world. From landmark rulings to policy shifts shaping the justice system, DLC brings you in depth coverage, expert insights, and analysis that matter. Stay informed, stay ahead because in law, every verdict counts. Today is 5th February 2025 and we bring you news that matters. The first news for today is as follows. In a significant judicial development, the Supreme Court of India has authorized the Na High Court to proceed with the direct recruitment of 158 civil judges, setting aside a state government circular that had previously halted the process. The bench, led by Chief Justice Sanjeev Khanna, and including Justices Sanjay Kumar and K.V. Vishwanathan, issued this directive on February 4, 2025. The court's interim order allows the High Court to continue the selection process notwithstanding the Na government's the 15th of November 2024 circular that had suspended direct judicial appointments due to amendments in reservation policies under the Na Judicial Service Recruitment Amendment Rules 2024. This decision comes amid concerns over significant vacancies in Na's lower judiciary, which have been contributing to a backlog of over 20 lakh pending cases. As of August 2024, 16.4% of judicial positions in the state's district and subordinate courts remained unfilled, exacerbating delays in the justice delivery system. The Supreme Court's intervention underscores the judiciary's commitment to addressing these vacancies promptly, aiming to enhance the efficiency of the legal system in Na. Next news. In a recent directive, the Supreme Court of India has instructed the Union government to provide detailed information on the number of individuals declared as foreigners who have been deported to their respective countries. The bench, comprising Justices Abhay S. Aukar and Ujjal Bhuyan, also sought clarification on the government's strategy for handling individuals identified as non-Indian citizens whose specific nationalities remain undetermined. This directive emerged during proceedings addressing the prolonged detention of foreign nationals in some transit camps. The court expressed concern over the state's failure to initiate deportation processes for detainees whose nationalities are known, leading to their indefinite confinement. The Solicitor General Tushar Mehta categorized the detainees into two groups: those declared non-Indian citizens with known nationalities and those whose nationalities remain unidentified. The court emphasized the need for the Union government to outline a clear approach for managing cases where individuals are stateless or their citizenship is uncertain. The Supreme Court has granting the Union government 1 month to submit a comprehensive affidavit detailing the number of declared foreigners deported thus far and the measures implemented to facilitate these deportations. This development underscores the judiciary's focus on addressing the complexities surrounding the detention and deportation of foreign nationals, particularly in regions like Assam, where the issue has been a long-standing concern. Next news. In a recent directive, the Supreme Court of India has criticized the Assam government for indefinitely detaining individuals declared as foreigners, citing the absence of known addresses as a reason for delaying deportation. The bench, comprising Justices Abhay S. Aukar and Ujjal Bhuyan, emphasized that the lack of a foreign address should not impede the deportation process. They instructed the state to initiate immediate deportation proceedings for 63 individuals whose nationalities have been confirmed, underscoring that indefinite detention violates the fundamental right to life under Article 21 of the Constitution. The court expressed dissatisfaction with the state's explanation, highlighting that the absence of a specific address should not prevent deportation. Justice Oka suggested that individuals could be deported to the capital city of their respective countries if specific addresses are unavailable. The bench also noted that the state's affidavit lacked sufficient information regarding the steps taken for deportation and deemed it per se defective. This ruling underscores the judiciary's commitment to upholding the rights of individuals and ensuring that administrative processes do not infringe upon constitutional protections. Next news. In a pivotal ruling, the Supreme Court of India has determined that appeals filed by accused individuals or victims under the National Investigation Agency (NIA) Act should not be dismissed solely because a delay exceeds 90 days. The bench, comprising Chief Justice Sanjeev Khanna and Justices Sanjay Kumar and K.V. Vishwanathan, emphasized that such appeals must be considered even if filed beyond the stipulated period, provided sufficient cause for the delay is demonstrated. This decision addresses the constraints imposed by Section 21(5) or the NIA Act, which mandates that appeals be filed within 30 days of a judgment, with a permissible extension up to 90 days if justified. The court's ruling clarifies that exceeding this 90-day limit should not automatically result in dismissal, thereby safeguarding the rights of appellants to seek justice. The Supreme Court's directive aligns with previous judgments from various high courts. For instance, in September 2023, the Bombay High Court held that appellate courts possess the authority to condone delays beyond 90 days in NIA cases, emphasizing that access to justice is a fundamental right and should not be hindered by procedural constraints. This ruling underscores the judiciary's commitment to ensuring that procedural technicalities do not impede the delivery of justice, particularly in cases involving serious offenses under the NIA Act. Next news. In a landmark decision on February 3, 2025, the Supreme Court of India ruled that one-sided forfeiture clauses in apartment buyer agreements constitute unfair trade practices under the Consumer Protection Act. The bench, comprising Justices B.R. Gavai and S.V.N. Bhatti, dismissed an appeal by Godrej Projects Development Limited affirming that forfeiting 20% of the earnest money upon cancellation was excessive and arbitrary. The court emphasized that such clauses, heavily favoring developers, are unreasonable and cannot be enforced to the detriment of homebuyers. This ruling aligns with previous judgments where the Supreme Court has consistently held that incorporating one-sided and unreasonable terms in agreements constitutes an unfair trade practice. In the case of Aereo Grace Realtech Private Limited v. Abhishek Khanna, the court observed that developers cannot compel buyers to adhere to unfair contractual terms, highlighting the necessity for fairness and balance in such agreements. The decision reinforces the judiciary's commitment to protecting consumer rights in the real estate sector, ensuring that contractual terms are equitable and do not disproportionately disadvantage buyers. Next news. In a recent judgment, the Supreme Court of India emphasized that laws designed to protect women from cruelty and dowry harassment should not be misused to settle personal scores or pursue ulterior motives. The bench comprising Justices Vikram Nath and Sandeep Mehta highlighted the necessity for courts to exercise caution in such cases to prevent the misuse of legal provisions. The court observed that criminal law should not serve as a tool for harassment or vendetta. It stressed that allegations in criminal complaints must be carefully scrutinized to ensure they establish a prima facie case before subjecting individuals to the rigors of a criminal trial. The bench noted that while provisions like Section 498 of the Indian Penal Code and the Dowry Prohibition Act are intended to protect women, they should not be exploited for personal vendettas. This ruling aligns with previous Supreme Court judgments expressing concern over the misuse of Section 498. In December 2024, the court criticized the growing tendency to use this provision as a tool to unleash personal vendetta against husbands and their families, noting that exaggerated and unsubstantiated allegations often led to the unnecessary inclusion of distant relatives. The court's recent decision underscores the importance of ensuring that protective laws are applied judiciously, preventing their exploitation for purposes other than their intended protective function. Next news. In a significant ruling on February 3, 2025, the Supreme Court of India clarified that while the forfeiture of earnest money in contracts is permissible, it must remain reasonable and not amount to a penalty under Section 74 of the Indian Contract Act, 1872. The bench comprising Justices B.R. Gavai and S.V.N. Bhatti upheld the National Consumer Disputes Redressal Commission (NCDRC) decision, which deemed the forfeiture of 20% of the basic sale price (BSP) by a builder as excessive and arbitrary. The court ruled that limiting the forfeiture to 10% of the BSP was just and fair, aligning with established legal principles. This judgment underscores the necessity for forfeiture clauses in contracts to be proportionate and not punitive, ensuring they do not contravene the provisions of Section 74. The court emphasized that while earnest money serves as security for contract performance, its forfeiture should not be so excessive as to constitute a penalty. If deemed excessive, courts possess the authority to reduce the forfeiture amount to a reasonable sum. This decision aligns with previous rulings, such as in Maula Bucks v. Union of India 1969 and Satish Batra v. Sudhir Rawal, 2013, where the Supreme Court held that forfeiture of reasonable earnest money does not constitute a penalty. The current judgment reinforces the judiciary's commitment to ensuring fairness in contractual agreements and preventing the imposition of punitive forfeiture clauses. Next news. In a recent directive, the Supreme Court of India expressed deep concern over the significant case backlog in the Allahabad High Court, highlighting that each judge is currently handling between 15,000 to 20,000 cases. The bench comprising Justices J.B. Pardiwala and R. Mahadevan emphasized the urgency of filling judicial vacancies to address this overwhelming pendency. The Allahabad High Court has a sanctioned strength of 160 judges but is presently operating with only 84, leaving nearly half of the positions vacant. This shortage has led to prolonged delays in case resolutions, with some matters pending for over 3 decades. The Supreme Court underscored the necessity of appointing suitable candidates based on merit and ability to mitigate this issue. This concern aligns with the Supreme Court's recent advocacy for appointed ad hoc judges under Article 224A of the Constitution to manage the backlog of criminal appeals in various high courts. The court noted that the Allahabad High Court has approximately 63,000 pending criminal appeal cases, with fresh appeals potentially taking an average of 35 years to be adjudicated. The proposed solution involves appointing retired judges as ad hoc judges to expedite the disposal of these cases. The Supreme Court's directives highlight the critical need for judicial reforms and prompt appointments to ensure timely justice delivery in one of India's busiest high courts. Next news. In a significant legal development, the Punjab and Haryana High Court has overturned a previous decision that denied permission to prosecute 4 members of a Special Investigation Team (SIT) accused of wrongfully implicating a school bus conductor in the 2017 Gurugram school murder case. Justice Kuldeep Tiwari ruled that the earlier refusal to grant sanction was arbitrary and lacked sufficient reasoning, rendering it legally unsustainable. The case centers on the tragic death of a 7-year-old student found on the premises of a Gurugram school in 2017. Initially, the Haryana police arrested bus conductor Ashok Kumar as the primary suspect. However, following public outcry and media scrutiny, the investigation was transferred to the Central Bureau of Investigation (CBI). The CBI later alleged that the crime was committed by a juvenile student, and that Kumar had been falsely implicated by the SIT through fabricated evidence and coerced witness statements. Subsequently, the CBI sought sanction under Section 197 of the Code of Criminal Procedure to prosecute the 4 SIT members, but the Haryana government declined this request in February 2021. Upon review, Justice Tiwari found that the sanctioning authority dismissed the CBI's request without adequately considering the incriminating evidence against the respondents. The court emphasized that the creation of false documents by the officials was a deliberate act intended to deceive, distinguishing it from mere inaccurate documentation resulting from negligence. The High Court's decision mandates that the sanctioning authority reevaluate the CBI's request, taking into account all presented evidence, and issue a new decision within 1 month. This ruling underscores the judiciary's commitment to ensure accountability within investigative agencies and upholding the integrity of the legal process. Next news. In a significant ruling, the Rajasthan High Court has directed the state to grant compassionate appointment to an individual whose father, a government school employee, passed away. The court emphasized that denying such an appointment, based solely on the applicant's prior conviction, for which he was released on probation, contradicts the rehabilitative objectives of the Probation of Offenders Act. The petitioner had applied for a compassionate appointment as a junior assistant following his father's demise. Although his previous conviction was disclosed during the police verification process, he was released on probation, indicating his rehabilitation. The court noted that the Probation of Offenders Act aims to reintegrate offenders into society, and denying employment on the grounds of a prior conviction undermines this purpose. This decision aligns with the court's earlier stance in July 2022, where it upheld the termination of an employee who had concealed pending criminal cases during the compassionate appointment process. In that case, the court observed that the individual failed to disclose critical information, violating the terms of the appointment. The current ruling underscores the judiciary's commitment to balancing the rehabilitative goals of the Probation of Offenders Act with the integrity of the compassionate appointment process, ensuring that individuals are not unjustly denied opportunities due to past convictions that have been legally addressed. Next news. In a recent decision, the Jammu Kashmir and Ladakh High Court addressed the issue or trial courts making observations on the merits of a case during the considerations or interim relief applications. The court emphasized that such observations are tentative and should not be construed as final opinions on the substantive issues of the case. The case involved a displaced Kashmiri Pandit who had purchased a plot and applied for building permission under Section 238(6) or the Cantonments Act 2006. After the statutory period elapsed without a response, the appellant commenced construction, which was subsequently halted by the Cantonment Board. The trial court dismissed the interim relief application, citing the appellant's failure to disclose a prior suit. The High Court found that the appellant had not intentionally concealed the earlier suit, and that such omission was not fatal to the current proceedings. The court also noted that the trial court had prematurely addressed substantive issues at the interim stage, which was inappropriate. This ruling underscores the principle that interim relief applications are not the appropriate stage for determining the merits of a case. It highlights the necessity for trial courts to avoid making definitive observations on substantive issues during the interim phase, ensuring that such determinations are reserved for the full trial proceedings. Thanks for listening and consider subscribing to the channel. Well, that's all for today. Keep listening to Legal News by DLC.